In June 2003, the legislature enacted House Bill 1204 to allow that Lowe's tract development, off-roading lane in Sunset Valley to proceed subject only to Travis County approval of plat application and related permits. Did you do anything to help get House Bill 1204 passed?
No.
Senator Wentworth wrote a letter to Councilmember Jackie Goodman. I should say I didn't actually put it as a question, but in my research, I know that when you argued a later case, you did actually bring 1204 into it. You did try to use it. You didn't have anything to do with getting it passed, but you did see it as a tool or an arguing point and a later decision. Senator Wentworth wrote a letter to Councilmember Jackie Goodman on November 5th, 2003, which encouraged her to support the settlement agreement that would have allowed Lowe's to build on the Garza tract with 40% impervious cover. Did you do anything to get the senator to write that letter or encourage him to write it?
No.
As you know, in December 2003, the Austin City Council voted to settle the Garza lawsuit. Lowe's paid $1 million for mitigation land to offset the 40% impervious cover, and the settlement would have allowed Lowe's to build. But then that led to another lawsuit when Sunset Valley sued. Sunset Valley Save Barton Creek Association and Save Our Springs Alliance sued the City of Austin and Lowe's to try to overturn that settlement. In January 2004, Sunset Valley filed a lawsuit, and you represented Lowe's. Is that correct?
Yes.
That settlement agreement with the City of Austin, completed in December 2003, allowed Lowe's 40% impervious cover, but Sunset Valley wanted, they had already, as you know, taken steps to remove the Lowe's tract from Sunset Valley's ETJ, putting it in City of Austin's ETJ, and therefore would make it fall under the SOS Ordinance. And that was really their aim with the lawsuit, as I understand it, is to get the 15% impervious cover of the SOS Ordinance to apply to the Lowe's development. Is that basically the thrust of what Sunset Valley wanted in that lawsuit?
I think so. I think they had gone through, and it's been a long time, so I'm not sure that I remember all the facts. What I remember generally was that the property owner in that case had moved forward with development on the city that it was in, Sunset Valley. And then right at the very end of that process, the city of Sunset Valley swapped land with the city of Austin or something like that, so that
they just annexed it from the ETJ, or if annexation is the right term. They removed it from the ETJ, and in the transcript of the court hearing on that case, you argued that that because it was removed from the ETJ of Sunset Valley didn't mean that it popped back into the ETJ of the City of Austin. That was one of the discussion points that you raised in the trial. According to the transcript, you stated that House Bill 1204 was among the reasons that Lowe's property was not subject to the SOS Ordinance. Is that correct?
I don't remember if we made that argument or not. Remember the thrust of the case being about what happens in a situation where a city's in a in a city's jurisdiction, and then and has gone through that process, and then right at the very end of it, there's an attempt to transfer the property from one jurisdiction to another jurisdiction. Whether on those facts, that's something that should be allowed. Right. Again, I think a pretty narrow fact pattern.
Yes. Okay. Well, Sunset Valley was obviously interested in the environmental protection because, from the standpoint of finances, had they left it in Sunset Valley ETJ, then they could have eventually reaped the tax base and the sales tax from the Lowe's. So I think that lends credence to the idea that they were trying to just get SOS compliance with the tract. In that same hearing before Judge Jenkins on July 1st of 2004, Dr. Lauren Ross of Glen Rose Engineering testified that leaking fuel from the storage tank on the Lowe's construction site was running directly into the aquifer. Do you recall that? It's in the transcript. Actually, I don't have that part of the transcript. She was introduced to the court, but she told me later that that's what she testified to.
I don't remember that specifically, but to the degree that any of that kind of thing was happening, it should have been stopped. They shouldn't be allowed to do that.
Well, that's what the court decided to do. They issued a temporary injunction against Lowe's, precluding further construction or the cleanup of the fuel and prevention of further contamination of the aquifer. Lauren even gave me photos that she took of the big fuel tank, fuel in the ground, pictures of it running into the aquifer. But as you said, if it happens, it should be stopped. Senator Wentworth wrote a letter to Mayor Will Wynn dated June 24, 2004, which encouraged him to prevail on his colleagues to ratify the second settlement agreement with the necessary 6 votes. The senator's letter stated it was, quote, absurd, unquote, that some argued the House Bill 1204 did not apply to the Lowe's development. He said, it is the very reason I presented this amendment in the first place. Did you do anything to get the senator to write that letter or encourage him?
No.
You're a candidate to be Austin's next mayor. What happens if you are mayor and the legislature or an individual lawmaker leans on you, like Wentworth leaned on Will Wynn and Jackie Goodman? Will you be taking instruction from the legislature to help developers, or will you be defending the laws the city council has enacted?
As a mayor, the city would be my only client.
Okay, that's fair enough. Ultimately, the Sunset Valley lawsuit was settled when the city of Austin entered a second agreement with Lowe's in March 2005. Lowe's got the 40% impervious cover that you fought for. By then, the city had already purchased several tracts to mitigate the impervious cover. Is that basically true?
Say that again.
I'm sorry. That's okay. Ultimately, the Sunset Valley lawsuit was settled when the city of Austin entered a second agreement with Lowe's in March 2005. Lowe's got the 40% cover that you fought for. And by then, of course, the city had already spent $1 million and bought up some mitigation land. I just basically want to be sure that one...
It's the timing part of that I'm not certain about. I know that the case settled with Lowe's agreeing to give them additional money over the $1 million. And with the city of Sunset Valley also pitching in, I don't know,
$350,000, and the city of Austin spent $350,000.
So my recollection is it was providing a fund for there to be additional lands, and I just don't know the timing on when the lands were purchased.
Well, they turned over the $1 million after the first agreement was made in December 2003. The city council voted 4-3. In fact, all 3 readings, it was always 4-3, 4-3, 4-3. And that's why in paragraph 17 of the original settlement agreement, it said it wasn't valid unless it had a supermajority, the 6 votes. But it would have went forward anyway had Sunset Valley and these other environmental organizations not sued. But and
that was before I was involved in the case.
I'm sorry?
And that was before I was involved in the case.
When did you? You didn't get involved in that initial lawsuit that resulted in the first agreement? Is that what you're saying?
I don't believe so.
Okay, that's an important point.
I'd have to check that too. Most of my recollections concern the second one, and my recollection was the settlement had a fund created for $2 million to buy land, and then certain restrictions on the development of the property, pretty significant restrictions. Mm-hmm. And I recall the attorney for SOS, after the case had settled that way, and saying that was a settlement that was good for the people in Austin.
Bill Bunch's comment on that's a little bit different. He said it was a compromise. It's not compliance with the SOS, therefore we didn't like it. Basically, but he lost, SOS. In terms of getting compliance with the SOS ordinance.
I'll see if I can find it for you. I think it was Brad.
Brad Rockwell, yes.
And I can see if I can find you his statement.
Yeah, I've interviewed him a couple of times, so I have something from him. But if you actually have a copy of the statement, that would be great, because then it would be current, and not something that's, retrospective and our memories change, and that was 10 years ago. So that would be great. Will you see if you can get that for me? I think I know the answer to this based on what you said before, but how does facilitating a Lowe's home center with 40% impervious cover, where the SOS ordinance would allow only 15% impervious cover, square with your claim to be an environmentalist?
Goes back to the answer that I gave you before. I think that the question that presented was a narrow legal question about the application of the law. could a city take a property owner who's gone through a development process and at the very end of it transfer the property over to a different, or attempt to transfer property over to a different jurisdiction?
Right.
I'm not sure that's a fact pattern anybody will ever see again.
Oh, no.
Right. So in my mind, it was a really narrow fact pattern.
Sunset Valley won 4 different court decisions in that case, and yet they wound up getting settled. And the drift I'm getting from people involved in the lawsuit on the other side were that there was, the foregone conclusion that the legislature was going to intervene once again and make sure that something happened to get Lowe's the okay to go ahead. Is that a fair characterization?
I wasn't involved in the legislative or lobbying component of that. I was focused on my kind of discrete
that was Terry
legal issues. I don't know really who was doing that.
He was one of the people that you represented him in a deposition that he gave that I did get a transcript from.
Right. I just don't know who. I mean, he was obviously, in and around that case.
Right.
But I don't know who was doing what outside of the lawsuit.
He took credit for him and a couple other attorneys in an Austin Business Journal article, and that came up in the deposition for having gotten 1204 passed. Okay. And that's why I asked you earlier if you were involved in it. He didn't name you, so I presumed you weren't. Else I'm sure he would have shared the credit.